All rise. Court of Appeals for the State of Kansas is now in session. The Honorable Stephen D. Hill presiding.
Please be seated. Good morning, everyone. This is the August panel for the Kansas Court of Appeals. My name's Steve Hill. I've been designated as the presiding judge on this panel. And I am honored to be on the same panel with my colleagues here. To my right, a grizzled veteran of our court, senior to me by a few months. He came on the bench in 2003, is Judge Tom Malone. To my left, one of our newer members of the court, but still well-blooded in the terms of Court of Appeals action, is Judge Hurst, and she joined our court in 2021. We have 4 cases set on the docket this morning. Our first case has been granted additional time as requested by the parties, and the presiding as the chief judge has granted extra time. We will proceed in order of the docket. If you have if you want to have a rebuttal, if your appellant's counsel, please let me know at the beginning of your argument, and I'll make sure you get that. Counsel, we have read your briefs, and we might have a few questions for you during your oral argument, so be prepared for those. You don't have much time, so I suggest you get right into it. And this is not like the Supreme Court where you have to give us a lot of factual background. We're fairly familiar with that, although we may have questions if there are details that we're not clear on. So be prepared for that. All right, first case is 127307, Stormont Vale Healthcare Incorporated versus Kansas Department of Health and Environment, the Division of Healthcare Finance. Counsel will hear. Let's have our appearances then from the appellant.
Good morning, Your Honors. Amanda Wilbert and Cameron Bernard for the appellant.
And do you wish to reserve time?
Yes, 5 minutes of time for rebuttal, please.
5 minutes. You've got it. For the Department of Health.
Morning, Your Honors. Darren Sharp and Matthew Langworthy on behalf of the Applebee's KDHE Division of Healthcare Finance.
All right, thank you. Let's hear from the appellant.
Good morning, Your Honors. May it please the court. We're here because the Kansas Medicaid program has wrongfully refused to pay for some of an inpatient hospitalization while a medical needs beneficiary was at Stormont Vale. Stormont believes the inpatient care was medically necessary as defined by the Kansas Medicaid regulations because it was the most appropriate level of care concerning the benefits and the harms to the patient. And it was also an economically efficient use of resources in light of the patient's unique characteristics. It is our position that the agency action denying reimbursement of the patient's hospitalization because Stormont Vale fails to look into a home health setting, erroneously interpreted the law, failed to apply the law, and is not supported by substantial competent evidence, and is ultimately unreasonable, arbitrary, and capricious.
Counsel, let me ask you this. This is an appeal from the agency, correct?
That is correct.
Where did the agency get it wrong? What's the essence of your argument?
The essence would be that the Kansas Medicaid regulations very clearly define how to determine medical necessity. And that is with 5 different criteria. We're really disputing 2 of those criteria today, mainly the scope criterion, where it asks us to determine whether or not a service provided is the most appropriate level of care based on the unique benefits and harms to the patient.
Now, is that to be determined by the doctor and patient, or is that to be determined by somewhere later, someone reviewing the documentation?
That is to be, there's supposed to be deference given both under statutory right or under the regulations, as well as under case law that's at district court, that the treating physician is to be given deference, or there's a presumption of deference to be given to the treating physician's position, because they're the ones that treated the patient, saw the patient firsthand, were well aware of the circumstances to
Did that
patient.
occur here?
No, it did not.
Why?
So the lower agency courts decided to, I'll say, cherry pick pieces of the treating provider's testimony and focus in on her response to a hypothetical, and that hypothetical should drive the day. Here, the treating provider laid out some very clear testimony about what she considered to be the risks to the patient if that patient was to be discharged. But even before that, the treating physician testified that the patient wasn't even stable for discharge. The patient did not have stable electrolytes. She was still receiving anti-nausea medication on a daily basis, and she had other complicating factors, such as an intellectual disability diagnosis that prevented her from really being able to care for herself. She needed constant coaxing and help during her medical admission to receive the nutrition that she desperately needed, both for herself and for the baby that she was carrying.
Do you think, sorry, Judge Hill,
No, go ahead.
do you think that deference means they had to take that physician's word and just use it no matter what? Is that how you understand the deference to be? What do you understand it to be?
So I understand it to be a presumption of deference. They're supposed to look at and give them kind of the benefit of the doubt, would be what I would think. And you know, certainly there's some district court decisions that look into, they don't need to accept the treating physician's opinion without some sort of criticism, but they have to reasonably articulate that decision or that their stance if they're going to not give it the presumption of deference. If they're not going to take the treating physician's decision, they need to articulate the reasons why. And really, we didn't see a lot of articulation of the reasons why they weren't going to give the provider deference. They talked about how her position, there was concern in her position because she talked about a Dobhoff tube versus the PICC line the patient ultimately had. But if you look at the treating physician's testimony and her concerns about the risks to the patient if they were to provide home health or to discharge her, it doesn't get into those items. The treating provider's decision or professional opinion that inpatient admission was the most appropriate for the patient had to do with her diagnosis, had to do with her unstable electrolytes.
It seemed to me that in the final order, they said they didn't give deference because the notes, there were two reasons. The notes were copy pasted. I'm not sure exactly what they meant, and I can ask KDHE if they just meant the case plan part was copy pasted, because I saw differences in the actual notes. So maybe that's what they meant. And that there was an error in one of the notes. And are those reasons to not give a treating physician deference?
Stormont Vail does not believe those are reasons to give the treating physician deference. The treating physician is not the only author of a medical record. There are many authors of a medical record, from nurses to dietitians to social workers. And so, you know, the medical record is a very complex documentation of someone's admission. And so those tiny little pieces of I guess reasons to not give her deference, we don't know if she's the one that authored the error to the extent that error actually existed. The other thing that I think that copy and paste piece has to do with, or why it should be disregarded, is because, you know, this was an extended stay admission. The patient was in the hospital for several weeks to receive nutrition throughout the end of her pregnancy. The plan of care is not going to change a lot
the plan of care is going to be, we need to get the patient nutrition, she needs to gain weight, we need to keep her electrolytes stable, and we need to keep her blood glucose levels stable. And so, that plan of care just isn't not going to change. The things to keep in mind are that they were constantly monitoring her vitals, monitoring her glucose levels, monitoring her electrolytes, and making changes to the nutrition that she was receiving based upon those particular results.
Now, they're gonna argue that that could be done in-home, correct?
Yes.
And under some circumstances, it likely could. As I'm reading through this, there's a lot of focus on the fact that Stormont Vale didn't look more into that. How does that play into the definition of medical necessity, that failure?
Our position is that failure shouldn't play into it shouldn't play into medical necessity at all, at least not at this point. When you're looking at the availability of something, you first got to determine whether or not it is the most appropriate level of service. Physicians don't necessarily, they can't call up a home health provider and say, hey, could you take this patient? The first thing the home health provider is going to say is, well, are they stable for discharge? Are they ready? What's their condition? And the response from the treating physician, at least in this case, was the response that she gave Sunflower, which is she's not stable. Her electrolytes are not stable. The things that she's receiving are not stable. And so you get this interaction that isn't going to move the ball forward in the care at all. You first have to determine, as outlined by the Kansas regulations, that scope criterion of what's the most appropriate level of care. And that determination, we believe, needs to occur first before we look into whether or not something's even available.
Could you explain something to me, because it's not clear from my reading of this case and record? When were these decisions made, these treatment decisions made?
So the treatment decisions were made on an ongoing basis. In the Medicare program, there is a process called utilization review, which often in these extended stay circumstances occurs on a concurrent or ongoing basis.
Now, when were these decisions made that you're complaining about?
So the decision was actually made, or the initial first true denial of the authorization for inpatient services occurred on October 8th.
So how long is that after?
So we're talking about 14 days of the patient's admission, from October 5th to when she delivered the baby via cesarean section on October 20th.
So and then there's an appeal period and a review period and all of that.
Right. And notably, that first denial of the inpatient admission on October 8th didn't mention home health at all. So while the beneficiary was still in our hospital and we could have called home health hypothetically, we didn't know, because they focused on the fact that she didn't, the written decision outlining the basis for denial of the prior authorization simply talked about how the patient's vitals were stable, she wasn't throwing up, she didn't have diarrhea. And so she should have been, the care she could have received was as outpatient.
I also, in reviewing your argument, am I correct in saying that you were arguing that the agency engaged in fact-finding?
Yes, they did inappropriate fact-finding or incomplete fact-finding.
Tell me why it was inappropriate or incomplete.
So while the agency articulated the characteristics of the patient or the patient's conditions, they laid that out in fact, but then didn't actually utilize it in their analysis. And one of the key considerations in the Medicaid process and in the Medicaid regulations, we have to think about or weigh whether or not a service is appropriate for the patient based upon their risks and the benefits, based upon the unique characteristics of that patient. And so while they mentioned some of her risks, they didn't actually weigh those later.
So if I understand your argument correctly, you're saying the agency just said it, they didn't show it.
Right. That's exactly correct.
Thank you.
They said it, they didn't show it, they didn't talk about it, they didn't weigh it. So we're left with okay, we recognize the patient's or the unique characteristics of the patient. But at the end of the day, shame on you, Stormont. You failed to call to see if something was available.
What relief are you asking for?
We are asking for a reversal of the agency decision and to direct reimbursement for this inpatient services, or at a minimum, a remand for appropriate fact finding.
So you think we have the authority to determine that they were medically necessary?
I believe you do. It's a legal analysis, right? I think from a legal perspective, the regulation, the regulation outlines the requirements, and the facts are there. They just didn't analyze them.
You still have plenty of time unless you want to reserve it.
No, I'll keep going.
You still have about 3 minutes.
Well, I'll reserve the rest of my time.
All right.
Thank you for that. I kept looking at the.
Okay, thank you. We will punish no lawyer for using less time. That's all right with us. Counsel? For the appellees, if you hear the sound of the ducks, your time has expired.
Excellent, thank you. Darren Sharp on behalf of the appellee KDHE, may it please the court. Your honors, there's a demarcation in this case that I think is important for the court to understand. The first demarcation, or that demarcation I should say, is August 21st, 2018. That's when this patient, DG, was readmitted to Stormont Vail. The reason why that's important is because there was a prior admission. That prior admission really has nothing to do and is not relevant to this appeal. However, Stormont is using the medical records and discussions that occurred between the treating physician of the patient and the physicians at Newman Regional Medical Center from Emporia, Kansas, which is where she was originally admitted before she was transferred to Stormont. And the reason why that demarcation is important is because of the old saying, that was then, this is now. So in other words, relying on medical records and discussions between the treating physician and the physicians in Emporia about whether this patient could be discharged because of her intellectual disabilities, whether she had a feeding tube, whether she had any kind of IV, that was based on her medical condition in early August of 2018.
So it was a different woman
Same
that came to
woman,
Topeka than was the Emporia?
same woman, but different condition.
Different intellectual disability.
No. I mean, her intellectual disabilities hadn't changed. My point is that in August of 21st, 2018, she began getting treatment using total parental nutrition, TPN. This is when a tube, a PICC is inserted, and your minerals and your electrolytes and all of your nutrition is then intravenously provided.
I realize that. Let me interrupt you with what's
Sure.
the most important question for me. In briefing this, the Stormont alleged that home health generally does not take care of pregnant individuals. And I believe in the response to that, there was an agreement on that. And in the district court's fact finding, fact number 47, the district court finds home health generally does not take care of pregnant individuals. Now, those are the facts of this case.
Generally,
And with those established facts, I am puzzled by the focus of the State Appeals Committee on the fact that Stormont didn't investigate home health care when it's pretty clear that generally they would not have been able to find any home health care for this patient who was not only pregnant, but had all sorts of special needs. So what's your response to that?
my response is generally that is true, but the problem with this is during the utilization review process, which my colleague had mentioned earlier, under the Kansas administrative regulations, the way it's supposed to work is the managed care organization, in this case Sunflower Health, on behalf of KDHE, reviews the medical records asks about the appropriate level of care and whether there's any other interventions that would be more cost effective or appropriate depending on the level of, or excuse me, depending on the patient's records and the patient's status. In this case, it was apparent from the medical records from August through September that she was getting better. She was becoming stable. Her TPN, the total parental nutrition, was eliminating her vomiting, her diarrhea. She had no fever. Her glucose levels were stabilized.
Well, weren't they giving her insulin to stabilize?
They were giving insulin through through the TPN. In other words, it was being provided the medication through her PICC line.
So her glucose wasn't stable just because, it was stable because they were
It was stable
administering-
because they were monitoring it.
Okay.
They stuck her finger and monitored her blood glucose.
And then they changed.
And then
the
would adjust
medicine.
it depending on when it was.
Okay.
However, the medical records from October 5th through October 20th, that's the period of time only that the KDHE refused to pay for inpatient services. Her glucose levels were stable. There were only a couple of times when they had to adjust the glucose levels. That doesn't mean it's not stable. They were treating the glucose depending on her labs. And at that point, her labs was only taken one time a day with a prick of her finger. And then if it was determined she needed some more or less glucose, it was adjusted accordingly. And so back to your question, Your Honor, I think what I'm trying to say is, generally speaking, that may be true. They asked for, my client asked for could you check, is home health care available for this patient? Because she was clearly only doing two things: having her finger pricked, having her glucose levels checked, and then adjusted accordingly based on her TPN. Everything else was normal. Her care, treatment, her plan never changed during that
She wasn't
time.
taking Zofran IV during that time?
That was also provided, but again, all of that medication could have been provided through her
Which
PICC
home
line,
health agency?
through a home.
was- Which one?
We don't know because we asked for Stormont to check and determine whether it was ever available, and they never
The
responded.
judge seemed to explain that had Stormont just made a phone call that he recognized probably wouldn't have mattered anyway, that would have made all the difference in this case.
I think,
And to me, that just doesn't seem like the proper way to sum up medical necessity.
are you referring to, I think, the judge in the Shawnee County District Court?
Right.
He did say that, but at the end of the day, that's how the utilization review process works. We don't know. We have no ability to answer the question, could home health care have taken care of this patient?
Well, you do though, because the definition of medical necessity is looking at the records and determining if inpatient care was medically necessary. There's a bunch of records that indicate she wouldn't be a good candidate for home health care because it didn't look like she had an OB at home who would actually deliver the baby. Is the plan to like come back to Stormont and deliver the baby?
I disagree with that assertion because the medical records actually indicated that, again, they're relying on the first admission from August. Those medical records said that the OBGYN in Emporia said, we can't take care of her on an inpatient basis. She didn't say we can't deliver the
No,
baby.
she said we can't treat psychiatric. I won't accept a psychiatric patient.
So in other words, she couldn't be sent back to Emporia to be treated as an inpatient in that hospital. That doesn't mean she couldn't have stayed in her home, had home health care show up 3 times a day.
There's a home health OB who does like OB visits.
That I don't know, but what my point is she could then deliver the baby in a
Where?
hospital, but she wouldn't have been admitted
Yeah,
to
but
have
there's
her
more
treatment.
care that when you're pregnant,
Mhm.
there's more care that you need. Like you have to see an OB during the end of your pregnancy.
Right. And she could have gone to a health or an OBGYN in Emporia and then gone home, right? And then go back when it's time to deliver.
She didn't have an OBGYN in Emporia, unless I'm misreading the
No,
record.
she had an OBGYN. The OBGYN said, we cannot admit her and take care of her TPN as was being done in Stormont. And
So
again, that was from the first admission. The second admission, the medical records show that her condition changed dramatically. And the point was, please go check to see if there's home health care. Because according to Dr. Roddy, who is the medical director with Sunflower Health, he testified, we have home health care all the time going to persons with intellectual disabilities who have PICC lines or even feeding tubes. And what they do is they show up 3
Pregnant
times a day. I'm sorry.
Pregnant one. I didn't
I-
remember him testifying that they
Yeah.
do it all the time for pregnant ones. I did remember him testifying that it's very normal to be very nauseous at the end of a pregnancy. I think the difference that we're looking at here is the definition of medical necessity has these criteria in it, and I don't understand why a failure to investigate home health care means that the notes don't show medical necessity. That's the trouble I'm having.
As we know, there's 5 parts to the definition of medical necessity under the Kansas Administrative Regulations. 3 of them, the parties agree apply, but they're not in dispute. One of those I think we have to point out, though, is the authority. And it's, quote, "The health intervention is recommended by the treating physician and is determined to be necessary by the secretary."
One's not on appeal.
But I'm saying they acknowledge that applies. And so my client has to be involved in reviewing medical records
Absolutely,
and
they have to
determining medical
determine
necessity.
medical necessity.
And so the scope is defined as the health intervention provides the most appropriate supply or level of service considering potential benefits and harms to the patient. We have a stable patient who's getting TPN every day intravenously. Her glucose levels are checked. Is that the appropriate level of care to just sit in a hospital for 3 months and
So
just
I
have her
think-
finger
I
pricked?
think you're right, that if she were stable and capable of doing home health, then there would be an issue here. But my concern is that the order doesn't demonstrate her instability.
Well, the order of the agency?
Right.
I think the medical records on which the order was based shows the stability. And that's a fact issue that this court has to defer to the agency. So as a fact-finding issue as to
But they
what did
didn't
the medical.
say the finding was that they didn't investigate. They didn't investigate and they didn't investigate.
Well, but the finding was originally that she was stable. Because she was stable, they should have investigated whether their home health care was available. Those records from October 5 through 20 of 2018, in the records or the order, the State Appeals Committee order shows that the glucose levels had stabilized using her medication that was administered through her TPN. Her electrolytes were stable. Her medication was administered through TPN. Her diarrhea and vomiting were controlled. She wasn't losing weight. Her weight was stable, which was the real reason why she was admitted. She had lost so much weight in so little time. So at the end of the day, the PICC line and the total parenteral nutrition had stabilized her. All that needed to be done was once a day, take her labs from a blood draw from her finger prick, check her glucose levels, and then provide her through TPN any adjustments that would be necessary. And
One of the conditions I think that demonstrated the need for inpatient care in the beginning was her psychiatric condition. But I don't see anything about that in the final order.
well, my understanding is from the original Emporia admission that she had been cleared, if you will, by the psychiatrist.
When?
That would have been in early August in the first admission.
So in early August, she became able to receive home health care.
No. What I'm saying is the home health care would have been available once she became stable, which then would have occurred from October, from October 5 through 20.
So her
She could have been-
psychiatric condition had no impact
No
on
impact.
whether or not
No
she could
impact.
do this at home.
Correct. I mean, and this is the other thing that I think has to be noted. The agency did take into account the characteristics of this patient.
Where?
Because, let me explain,
Okay.
if this was a person without any intellectual disabilities, they would have been educated on how to take a finger prick, how to check your glucose, how to call your doctor and say, here's what my glucose is, and clean the PICC line. They would have been sent home on their own. But this patient had intellectual disabilities, and the concern was, you can't do this. She demonstrated that because one day later, she was readmitted to Stormont when she was first checked out, right? And so the point was home health care can take care of this patient. They'll come in 3 times a day. They'll do all the work. All she has to do then is allow home health care to come into the home. But we don't know even if that was possible because Stormont Vail simply ignored the request. Can you please check? Can you check?
But they didn't think it was medically appropriate.
The doctors,
Right.
but the reason why they're providing the basis was from all the discussions that occurred in that first admission, right? That she was admitted and then ultimately discharged on August 20th.
But I don't understand what changed other than the fact that she was now not losing weight because she had the TPN.
Correct.
So what else, like, I'm looking at the final order, because that's what we're reviewing on appeal. I'm having a hard time understanding the application to her specific conditions that made her inpatient in the first place.
She was admitted because she had a hyperemesis gravidarum, severe morning sickness. She was throwing up, couldn't keep anything down.
Right, she
And
lost
so
a
she
lot
lost a
of weight.
lot of weight.
Yeah.
When ultimately, I think it was on August 29th, the PICC line was inserted and she had total parental nutrition, TPN. She no longer ate anything. Everything was going through
No,
her.
I mean, I understand that. I'm saying
And
what,
so and that's what changed. She then became stable. She wasn't losing weight.
She
She
became
gained 9
medically-
pounds. She gained 9 pounds.
you're saying she medically was not losing weight anymore, and that's the only criteria upon which she was inpatient.
And her vomiting and her diarrhea was not in any way what it was before, which shows the fact that even though intermittently she was nauseous and had some diarrhea, it didn't affect her weight. She had gained weight. She had controlled her weight and added to her weight on TPN, which is
So
the
for how
reason,
long had she been doing that? I don't
since
see that in the order.
Dr. Roddy testified that as early as September 19th through September 27th, that the record showed she had become stable. That under the Interqual 2017 Acute Adult Extended Stay Standards, which is part of the utilization management review process, she didn't qualify for inpatient services. He then said, go find if there's home health care. And if there is, I'll extend the pay through October 5th. Get back to us. They never did. And so then I want to make sure it's clear that KDHE and Sunflower approved payments for this inpatient care from August 21st through October 4th. They paid for the inpatient services from October 21 through 23, which was the delivery part of her stay. Denied payments for October 5 through October 20.
Why?
So,
Why? Just basically give me a quick answer. Why?
because she was stable and the services provided as an inpatient basis,
Were unnecessary?
all she was getting was a stick of the finger and the TPN. which
So
could
that
have been
wasn't
done.
necessary. The TPN wasn't necessary anymore?
The billing as an inpatient, okay, because then what happens is you pay for all.
So the problem is she was an inpatient.
She was.
You should have done this. What you're saying is the SAC, whatever you want to call them, the State
Appeals.
Committee says, well, you should have done that. So they're substituting their judgment for the doctors. You should have, because we're not going to pay for it. Is that what you're saying?
No, not at all. I don't think.
Are they substituting their judgment for the doctors?
Not at all. Not at all. The process in a utilization review management for Medicaid is that it's an ongoing process. Okay, the doctors don't have 100% deference. They can say, here's our plan. This is what we want to do. But the administrative regulations show that during this process, that the KDHE through its managed care organization can ask for documents and ask questions about future care and treatment and say.
The only question here was, you didn't explore these what
Yeah.
Judge
Home
Mullen
healthcare.
referred, home health care.
Yeah.
That was their only failing. They didn't explore, and you didn't send us documentation that you didn't explore this home health care, so we're not going to pay for it.
That was a primary reason, Your Honor, yes.
So all of this other boils down to this. You didn't show us, you didn't make this phone call like the district judge said. And so we're not going to pay for it.
You should have at least looked into the possibility of another alternative healthcare intervention, which is the definition of scope, because the medical records would justify home health care.
Now, did you send notice of that to them? Look, you better go out and check this or we're not going to pay for it?
According to the record, the medical director instructed Nurse McKee to call Stormont Vale and say, investigate home health care and get back to us. You've got payments approved through October 5, let us know. And then nothing happened.
Did she do that?
I don't know. She being Miss McKee?
Yes.
My understanding is yes, the records show she did. What Stormont did to investigate, if anything, I don't know. I don't think the record shows that.
So she told them, she put them on notice, if you don't do this,
Right.
you're not going to get paid.
I think that was implicit, Your Honor. I think everybody understands that
Oh,
you have to do.
it was hidden in the words. If you don't do this.
No, it's in the administrative regulations. 30-5-81, C, as in Charlie, paragraph 3, 6, and 7. And I'm happy to read them, but it basically says that they're not going to pay for inpatient services when it could be done on an outpatient basis.
Right, when it's medically not necessary and it's more appropriate on an outpatient.
Correct.
And they're saying it is medically necessary.
But
And
the
what
agency,
what I'm having trouble seeing here is an analysis of the medical necessity of the inpatient care. I hear that they didn't investigate. I'm unfamiliar with the regulation requiring investigation. I do understand the regulation requiring it be medically necessary. And so that's the
Well-
problem I'm having.
I think the medical records that were submitted, that are in the record, that the State Appeals Committee and the ALJ and the district court looked at, they deferred to the agency on interpreting those medical records that this patient was stable at that point between October 5th and October 20th. And this court also has to defer to the agency on that issue. It's a fact issue.
Well, I understand that you're saying her stability is a fact issue. What I'm saying is that not the agency isn't supposed to look at medical necessity. You're saying that only Sunflower looks at it and then the agency defers?
No, I'm saying it's a dialogue. Utilization review management process. And if the agency has a question about whether the level of care is appropriate or could be provided at the same level of care in a more cost-effective manner, the regulator has every right to ask the medical provider who receives Medicaid funds, public funding, to investigate, is there a possibility to do something differently because the records showed this patient was stable and could have home health care. But whether she could or not, we don't know if it was ever provided because Stormont didn't.
They're saying she wasn't stable. They're saying she
Again.
wasn't stable and you're saying she was stable.
She was.
And so that's the issue. They're saying she was, and the question is then, does this order demonstrate medical necessity of inpatient care?
The order has already found that the records as a fact issue show that she was stable.
Well, no,
So
medical necessity is a definition, legal definition.
it is a legal definition, but it's based on medical records. And medical records, you have to defer to the testimony of the doctors, the treating physician, and the medical director for Sunflower. Thank you.
You've heard that, well,
I heard
don't walk
the
away
ducks.
yet. You heard the sound of the ducks, but I got a couple of questions.
Oh, okay.
First of all, do we have to defer to the district court's findings?
The findings of fact, I believe you do.
Did the court hold a trial or just review the same record we're reviewing?
The court reviewed briefs, the petition for judicial review, and had oral argument.
So you think we're bound by the district judges since we have the same record that the district judge did, with the exception of the appellate briefs?
I think you're bound, the only de novo review is whether, is legal issues.
I see.
That's
Now, the other thing, do you think we're making, your colleague, your opposing colleague said that we're making a medical decision? Are we,
no,
are we making a medical decision here? Are you asking us or
No.
are they asking us to make a medical decision?
I think they are asking you to, interpret medical records and find legal decisions from those medical records. And I don't
You're
think
not.
you can. I don't think you
But
can.
you're not.
No, the agency and the doctors are the ones to make those fact issues, and then the agency deferred to the doctors and the medical records.
Thank you, counsel.
Thank you.
Ms. Judge Malone? Judge Hurst? Okay, thank you.
Thank you.
Counsel, you've got your 5-minute rebuttal.
So there's a couple of things, thank you, Judge, that I want to address or maybe clarify. The first thing is that it's Stormont's position that to limit the medical records reviewed in this particular case to those in the second admission is just illogical and unreasonable. You know, when the doctors are there treating patients in real time, they have access to a patient's entire medical record. It's not distinguished by a particular date. They get to, you know, open it up in their EMR and look at it. And so to limit the scope of what we're looking at to that second admission and the conversations that have occurred and talked about, they flow throughout the admission. And frankly, if you look through the medical records, you'll see the physicians and treating providers refer to other conversations that happened before her initial admission or conversations that happened at those different times.
Do the doctors, when they're making those decisions right then, only look at the conditions right then, or do they look at all of the history of the patient?
You're gonna look at the entire history of the patient because you never know when those comorbidities are going to resurface. Just because somebody's psychiatric condition may have been controlled at a prior date and time doesn't mean that it's going to resurface itself if it's not being treated in an appropriate manner, or because there might be some sort of condition or thing that happens that aggravates that condition. I mean, being pregnant is a very stressful thing. And it's unknown whether or not that piece is going to resurface itself.
Can you answer Judge Malone's question?
He asked a couple, which one would you like?
Well, the one concerning the phone call.
So I encourage, I guess, either the court or to look at what the question was, the question that Cheryl McKee actually documented in the record. She called, and according to what's in their prior authorization record, she called and asked Stormont, is home health appropriate? She didn't ask if it was available. She didn't ask if it, if it was something. She asked if it was appropriate. And there was a peer-to-peer that occurred after that phone call in which Dr. Bray is the only doctor that testified at the hearing that attended that. But, Dr. Bray testified that she would have talked about whether or not she felt home health was appropriate, and that in her position at that time was that the patient wasn't medically stable for discharge, and therefore home health wouldn't have been appropriate. And so it's unknown. I mean, it's not in the record whether we specifically returned that phone call. And two, I guess I would also say there's testimony in the record from Sunflower's medical director that Sunflower has this network of home health and they could have called too. And so, we're not the only people that could have called to inquire about home health. And from our perspective, again, going back to the regulations that govern this case and govern medical necessity, we have to look at whether or not an intervention was the most appropriate level of care. From Stormont's position, the most appropriate level of care was inpatient admission, and it's frankly a waste of resources to look into whether or not a different level of care is available if we don't think it's appropriate. I'd also argue that she wasn't just receiving essentially a prick of the finger and the TPN piece of it. There was a lot of other services that were being provided and a lot of other analysis, whether it be electrolytes, the coaxing, the nursing care that this patient was receiving throughout her admission, and which all goes to Stormont's position that she was not medically stable to receive outpatient care. And I think much to Judge Hurst's position, we don't see an analysis in the final order or the ALJ order about whether or not that was accurate. We jumped straight into this failure to call.
Let me ask you about the position. I think what I'm hearing from KDHE is once Sunflower determined she was medically stable, so that seems to be a disagreement between Stormont says she wasn't, KDHE says she was on a certain date. Then that was medical necessity determination, and that determination is given deference then by all of the agencies that look at it.
So I would disagree with that piece of it. I mean, we still need to have, much like case law relating to substantial facts, we're not going to scour through the records or make some assumptions about whether or not they've made a decision or that they've made it. They need to state it. And so from here, we still I think have this is, or we're all sitting here assuming that the SAC or the ALJ made findings on stability. And so we're going to jump straight to the availability of things, but they need to articulate it. The medical record or the Kansas regulations outlining medical necessity require that you look at those facts. You can't just jump to those conclusions and make accept us all to, I guess, go with it.
Thank you, Counselor. You heard the ducks.
I heard the ducks. I appreciate the ducks.
Very interesting case. Thank you, Counsel. We'll take it under advisement and issue a written decision. We'll proceed to our next case on the docket. 127715. Troy Allen Martin versus the City of Topeka. Counsel for the appellant.
Good morning. May it please the court. I am Chloe Davis, and I'm here on behalf of appellant Troy Martin this morning.
And are you wanting to reserve any time for rebuttal?
Yes, Your Honor, 3 minutes, please.
3 minutes. Hold on just a second. And for the appellee?
Yes, Your Honor. Nick Jefferson appears on behalf of defendant appellee, City of Topeka.
Thank you. Proceed, counsel.
Good morning, Your Honors. May it please the court. Thank you. As I said, my name is Chloe Davis. I'm here on behalf of appellant Troy Martin this morning. I appreciate your time. This is my first time doing appellant oral argument, so I appreciate all of the questions I hope that are coming my way. I will jump right into it.
The only thing you have to worry about is the ducks.
Understood, Your Honor. Thank you. Thank you. As the briefing demonstrates, Your Honors, the facts here are rather straightforward. They're not very extensive. Mr. Martin was driving down the 4800 block of Southwest Topeka Boulevard in July of 2019, and he hit a pothole at that, flipped his vehicle and ejected him from the vehicle, and he suffered extensive injuries. While Mr. Martin was driving, he had a car in the lane next to him, so there was no way for him to avoid encountering the pothole. Mr. Martin filed his petition with the district court in Shawnee County seeking relief, and we went through the discovery process, and the city filed a motion for summary judgment.
Now, summary judgment was granted in this case.
Yes, Your Honor.
And if I recall correctly, there were 2 or 3 allegations of fact that he controverted. Tell me about that, please.
Yes, Your Honor, thank you. So, of course, this court, I'm sure, is familiar with Supreme Court Rule 141 that requires in summary judgment briefing for the non-moving party to address paragraph by paragraph and cite to the supporting facts. When Martin responded to the motion for summary judgment, facts 9 and 11, as movement had written them in responding in Martin's paragraph, he cited to his own statement of facts 12 through 36, which if you go look at 12 through 36, they are assertions of fact that they are keyed to the record. And I think my understanding of the lower court's decision was that that did not satisfy Supreme Court Rule 141. And it would be our position here today that that finding was erroneous and arbitrary based on the fact that the point of Supreme Court Rule 141 would be to let the court know whether or not the fact is controverted and what evidence is being relied on in controverting that fact. And it would be our position that the response to the city's paragraph did that.
Well, what's wrong with those two findings of fact, contentions of fact.
So, finding of fact 9. The court found that, the city's fact 9, which basically said that the city had no notice of the pothole, was uncontroverted. That creates an issue in terms of duty or breach under the negligence analysis, because if they were unaware, according to the law, then they had no duty.
I understand that, but what's wrong with that statement of fact? I mean, you're making a legal argument there. Do you have proof or evidence, or is it your position that the city knew about that pothole?
It would be our position that the city had knowledge of the disrepair in the area. We will acknowledge that there is nothing in the record that indicates that the city knew about this specific pothole. However, I do believe that it creates a rabbit hole. If there's a pothole 2 feet away, do they know about that pothole? The city was very much aware of the dilapidated conditions, specifically of the 4800 block of Southwest Topeka Boulevard. And further, Your Honor, as you mentioned, it is also our argument that if they did not know, that they should have known based on the facts outlined, specifically 12 through 36, which are 29 different instances of citizens complaining about that stretch of roadway. As to fact 11, Your Honor, the city's fact 11 basically said that how the city maintains the roadway is discretionary, and it goes into all of the different considerations that the city takes into consideration when deciding how to fix these potholes.
That strikes me as being a legal statement rather than a statement of fact.
In terms of their fact number 11, Your Honor?
Yes, it says it's discretionary. It's a description, isn't it?
Your Honor, I do have the exact language, but I think their specific sentence said that it lists the considerations that they take into, like cost, timing. So I do think that their fact was, and I would like to agree with what you're saying, that it was a description. What they're saying, in essence, is that all of these different considerations make this decision discretionary. Our position isn't that how they go about fixing these potholes isn't discretionary. I'm not an engineer. I don't know how you fix a pothole. What I do know is that you have a duty to fix it, and how you go about that may be discretionary, but the duty itself is not. Your Honors, one of the issues with the lower court's decision is that it's our position that several of the arguments just weren't addressed. Maybe by way of the ruling itself, they were addressed, but they weren't exactly analyzed by the lower court. So I think largely, for example, the argument that the public duty doctrine and the Kansas Tort Claims Act are conflicting. It's our position that this largely was not addressed by the lower court. And so the remedy that we request is largely remand so that can be analyzed. As stated in the briefing.
You're asking us to remand for further argument? What are you asking for?
For the lower court to determine, based on further argument, further fact finding, whether or not the public duty doctrine and the Kansas Tort Claims Act can apply at the same time.
We can't determine that. The three of us can't decide that.
You can, Your Honor. As cited in the briefing, typically you would remand for the lower court to make that determination. We're happy for this court to make it as well, based on the.
What would you urge us to rule then?
We would urge you to rule that they cannot exist at the same time, which I understand is novel. I understand that. When I read it, the public duty doctrine says to me that when you're analyzing whether or not this duty exists, the alleged duty does not exist if it is a duty that's owed to the public at large. When I look at a city, it appears to me that 99% of the duties that they have are owed to the duty at large. And the Kansas Tort Claims Act says that liability is the rule and immunity is the exception. The public duty doctrine by its very nature says the inverse of that. And so when you're trying to square the two, if we're bringing a negligence action then obviously the Kansas Tort Claims Act applies. And based on well-established, understood rules of construction, this court knows that a statutory framework is going to take precedent over common law. And so it's our position that in terms of not only plain language, but application, the public duty doctrine and the Kansas Tort Claims Act cannot be reconciled.
Do you have any case authority that supports your position?
I do not, Your Honor.
Is there any case authority that opposes your position?
There are lower court, district court rulings, Your Honor, that while they don't necessarily address the argument that I'm making in terms of interpretation, they do apply both at the same time. And so by implication, yes, but none of those decisions that I've seen address the argument of interpretation.
So it's your position that any time a negligence action is brought under the Kansas Tort Claims Act, we cannot apply the public duty doctrine?
I think there could hypothetically be times, Your Honor, that you could. When looking at the Kansas Tort Claims Act and the spirit behind the Kansas Tort Claims Act, it's hard for me to find a hypothetical scenario where you could. So I don't want to foreclose it
Go
because
for it. We appreciate the argument.
I don't want to foreclose it because that seems unreasonable. But yeah, when you think about the doctrine of the public duty doctrine, it says if the duty is owed to the public, there's no duty to a member of the public. And to me, when you look at the Kansas Tort Claims Act, as I don't need to be repetitive, but the spirit and the plain language of the Kansas Tort Claims Act doesn't seem to agree with that. Further, Your Honors, arguing that the public duty doctrine does apply. So setting aside whether or not it should, just arguing that it does apply, we did argue that some exception should apply. And we also acknowledged that the argument made on this front was novel as well. We did argue that based on the special relationship between the parties, that the exception to the public duty doctrine should apply in the event that the court were to find that that doctrine.
What was the special relationship here?
The possessor licensee relationship. So we argued that the city has a possession ownership interest in the roadway and that the city requires for people who drive on the roadway to have a driver's license, which makes them a licensee. So the relationship there then is that of possessor and licensee.
Well, that license isn't issued by the city, is it?
No, Your Honor. The ordinance, however, is passed by the city. And largely, Your Honor, again, that argument just wasn't addressed by the lower court. So we would ask that either a remand or a determination be made on that argument by this court. Another exception that would apply to the public duty doctrine is I'm sorry, I misspoke. The next doctrine that was relied upon by the city is the open and obvious danger doctrine. The lower court found that the open and obvious danger doctrine did apply here. And there was a couple of unique findings as it related to this doctrine. So first, the lower court found that Mr. Martin knew or should have known about the pothole. And it is true that this pothole was very large, and it is true that Mr. Martin drove this stretch of roadway almost daily. He worked around that area, so he was driving there almost daily. However, Mr. Martin did testify that he did not know about the pothole. That was his deposition testimony, that he didn't see it the day before. He doesn't drive in the same lane every day, and he testified that he did not know. Additionally, we argued that even if this were an open and obvious danger,
Oh, go ahead.
that Mr. Martin had no way to protect himself from the danger. He's driving down the road. He's going the speed limit. He tries to avoid encountering the pothole. However, there's a car in the lane next to him. He's not going to crash into another car. And so he really had no way of avoiding the pothole. There were some determinations made by the court that Mr. Martin could have worn a seatbelt or slowed down. However, it's our position that those don't speak to a duty under a negligence analysis. Those speak more to contributory negligence or a damages analysis.
Thank you, counsel. You'll still have your 3 minutes.
Thank you, Your Honors.
Good morning, Your Honors. Again, Nick Jefferson on behalf of the city of Topeka. Counsel is correct. The city filed its motion for summary judgment in this case based on a number of reasons I'm sure you've seen in the brief. Essentially, the city has argued that the plaintiff has not and cannot establish a prima facie case of negligence, as the city owed no duty, there was no breach. And finally, the city is claiming an exception to immunity under the Tort Claims Act. Again, we talked about this, or you talked about this briefly. The first issue on appeal is the district court's finding of facts, namely those facts, number 9 and number 11. In regard to that finding of facts, I would of course ask you to, adopt the district court's finding of facts on those two issues. I see nothing that indicates that the court's decision was arbitrary or capricious on those two facts. I think, as we have argued.
Is that our standard
Yes, I believe it is.
on a motion for summary judgment? Are we bound in any way?
I believe when it comes to the determination of the finding of fact, it has to overturn it. You have to find the decision to be arbitrary or capricious, that is the
Or they
standard.
ignored substantial facts in the record to the
Correct.
contrary?
In regard to the issue of negligence, obviously the standard is de novo, and you can delve into that analysis. That's pure legal analysis. We believe that those statements were actually supported by the record, and I believe we showed that, especially if you go to the reply brief. But we also reference it in the appellate brief. We think it shows that those two facts in particular are well supported by the record, and we don't see any facts in the contrary. There's nothing specifically that shows that the city had actual knowledge of a pothole at that location prior to the incident. And I think counsel has said as much.
I'm interested in the concept of special relations. How does that work, counsel? In your view, how does that work?
Sure. I think, so in regard to the public duty doctrine, in order for there to exist a special relationship to exist, I believe there's 4 ways that the courts have said that could come about. 2 involve a custodial relationship. Now, typically that involves police officers, custody of an individual or a third party. The third is if some agent of the city or employee or someone made a specific representation to an individual, like to Mr. Martin, which we have no evidence of that in this case. And then a later court has also said that a special duty can arise through the application of a statute, a specific statute. And again, we have no statute in this case that applies that would create a special duty in this particular incident. So it is our position, and I think the district court agreed, that no special duty exists. Therefore, the duty owed under the public duty doctrine is to the public at large. And so no duty was owed to the plaintiff in this case.
Did the enactment of the Tort Claims Act strike a spear through the heart of this doctrine of law?
No, Your Honor. No, Your Honor, that is not my understanding, not the city's position. As we point out in the brief, there are a number of cases where the courts have decided that they've applied both. They've applied discretionary function immunity along with public duty doctrine. I think, the whole purpose really of the Kansas Tort Claims Act was to get rid of the old common law, sovereign immunity concept. The public duty doctrine is its existence is more of a balancing act that recognizes that government entities, I don't think it's 99% of the duties that the government entity owes is to the public at large, but a lot of them are. Again, a lot of that has to do with police protection, fire protection, duty and care maintenance of the roadways. These are typically duties that are owed to the public. The city in this case must provide safe roads to the public in a reasonable manner. And so I think that doctrine is still in place and it still serves its purpose to help balance the liability of a entity such as a government entity.
It's not a vestige then of the old days that where the king can do no wrong.
No, I think that the Torts Claim Act was designed to, get rid of that. And I think it has successfully done so. But I don't believe that the passage of that act negates the public duty doctrine.
Does your case hinge on the fact that the city didn't have specific awareness of this very specific pothole?
It does to some, yes, I think it does to some degree, because that was the allegation made initially, was that there's a pothole, he hit the pothole, this happened. As you read the briefing, you see we kind of morphed a little bit into a general sort of, well, that's when we get into the standard of care argument that we address at the end of the briefs. Because I think the plaintiff has taken the position of, okay, well, maybe you didn't know about this pothole, but you should have because your road was in such disrepair. Okay. And I think that argument could be made potentially if you had the evidence of that. I don't think we have that. I think that requires, you have to have special evidence that establishes this is the standard of care. And then you have to have evidence that you breached it. And we don't have, we can't even get to first base on that one.
So you don't think that an argument exists that the standard of care is that you were reasonably aware of the deterioration of this road and you should have done something about it?
I absolutely think that the city was aware of that the road was deteriorating. It's in the record that it had a PCI rating of poor, which actually falls in the middle of the rating scale. So it's not failed.
Disturbing.
I find that very discouraging that that's in the middle of it, that poor is very in the middle of it.
And I don't know the basis of how those words were chosen or what that type of thing. But that is, PCI is common. It's used across the country. But the point is you have to have some evidence that shows, okay, but is it so bad that it's failed and you haven't done anything about it, that you've done nothing? And that we just don't have any evidence of that.
So if it had been to failed, then you think the city would have had a duty?
Well, actually, and this is in the record as well, there's a sentence on that rating scale that a note, an asterisk that says, even if something's rated as failed, it doesn't mean that the road is unsafe for travel. So failed, to my understanding, is a designation that traffic engineers look at and go, oh boy, this needs to be our top priority. But see, that's exactly a discretionary type of decision, which we go into that as well. But whether or not a road needs a simple, we just need to go out and fill a few potholes versus we need to go out there, rip out the entire thing and replace it. That's the type of decision that you need specialized knowledge to make. That depends on finances. It depends on the engineering. It depends on what else you have going on in your municipality. So I just don't think we can get there.
Because of the discretionary nature of it, the exception is
Correct. Yes. And so we've sort of, just by process of having questions here, we've sort of discussed pretty much all of the city's points, but basically we would just ask that you, affirm the decision of the district court in this matter and find for summary judgment on behalf of the city.
Thank you, counsel.
Thank you.
As I said before, we will punish no lawyer for not using all of their time.
Thank you.
Counsel, you got your rebuttal.
Thank you, Your Honors. I will be brief here, just because it was touched on by Mr. Jefferson in the city and because I didn't get to it. In terms of the discretionary function exception, it would be our position that there is a statutory requirement that the city inspect the roadways. That statute is cited in the briefing, so I won't recite it here. However, it was our position that the inspections are required, and had they been doing those inspections, they would have known about the pothole. However, it's the city's position that they had no knowledge of the pothole. And again, I don't believe that argument was addressed by the lower court. So again, we would just ask that either that argument be addressed or remanded. And then earlier, Your Honor, you had asked about any case law, whether there had been any case law applying both the Public Duty Doctrine and the Kansas Tort Claims Act. One of those that's touched on in the briefing is the BNSF case against the city of Augusta. I would just like to call attention to that and point out why I've already kind of stated it, but why we think that this case is different from that case. Again, in that case, the lower court found that there was no requirement that the city perform inspections on the apparatus that caused the issue in the BNSF case, whereas it's our position that there was one here.
All right. Thank you, Counsel.
Thank you, Your Honors.
We appreciate your arguments on this interesting case. We will take it under advisement and issue a written decision. Do you want to move on? Do you want to go recess?
I'm fine with
Do you need
moving
a
on.
recess?
I'll be okay.
Okay. All right. We'll move on to the third case in our docket. 128-017, Brad McGivern versus the Kansas Real Estate Commission. Counsel, if you'd enter your appearances for me, for the appellant.
Pat Reardon.
And do you wish to reserve any time?
5 minutes.
5 minutes? Thank you.
Police Report Deputy Solicitor General Dwight Carswell appearing on behalf of the Kansas Real Estate Commission.
Thank you. All right. We'll hear from the appellant.
Good morning, and may it please the court.
This is the case where the buyer turns around and makes $46,000 off of a purchase of a house. Is that correct?
The number he made off the purchase can be disputed. It depends on how you look at, Your Honor, but yes, this is correct. This is,
Well, 50,000, 46, 40,000, somewhere in there. That's a pretty good day.
I would disagree that it was that much of a profit at the time.
Well, what, was it less than, what, 20,000?
I'd say it's about 19,000, 20,000, about a 15% increase over what he had told.
That's not a bad day's work.
No.
Turn around, make $20,000 profit off of a house that he bought.
That's correct, Your Honor.
He didn't have any additional knowledge about these things, did he?
No, Your Honor.
No, these two parties were in equal bargaining position.
Well, I didn't say that, Your Honor.
Oh,
I mean, he was a real estate agent.
uh-huh.
And at the time, the numbers that were used by the Kansas Real Estate Commission were numbers which came out after March. And that's the essence of one of the factual issues in this case. I understand there was a factual decision made in open court that's going to be given deference, but the big issue here is at the time the discussions were made in February, the county appraisal was 120. That's the number that was used. In March, after the contract had been executed, the county appraisals had gone up and the price of real estate was going up at the time too.
Wait, so you think the value of the house changed from February to March?
No, Your Honor. I mean, during that time period, it was an interesting time period for the real estate market. We can assume probably that it may have been above a little bit, over 120. The issue here is if we're going to find the appellant in violation of 813, did he know how much above the numbers he was quoting to the potential sellers were?
Does he have to know the exact amount above, or does he just have to know above? I mean, I think there's usually a process where they get comps, they print them out, and make some determination. Plus, real estate agents often know that houses in the area sell for more than the county. I mean, I'm in Douglas County and they sell for more than the county appraisal.
At times they had in Douglas County, but in Topeka,
That's not the case in Topeka.
not necessarily. But we're also talking about at this stage, an issue which has arisen in the course of this litigation, which is what is the scope or the standard under A13? Because it's fair to say that the language of that statute is strictly fraudulent or substantial misrepresentation. So are we talking about you knew? And the unfortunate thing is there's not a lot of case law or guidance that tells us how to interpret that conjunctive phrase. And so we're kind of now, when we talk about you should have done comps, you should have known, you should have had some better idea that the fair market value was 139 as opposed to 120. At that point, are we getting into a should or should have known standard, which the plain language of that statute just doesn't really articulate? Because fraud is you have to actually know that what you're saying, i.e. 120 is what I think you should expect from this house based on its condition, is different from saying I should have done all these extra things under a should or should have known standard. So that's probably when we look at how are we interpreting this case under A13, that's probably the first step is what's the standard? Is it actual knowledge or is it should or should have known? Because that's kind of reading into the statute. The second thing would be the factual issues, Your Honor, of what did he know at the time about the value of the house? Because I have a short period of time and we'll probably be coming back to this, I'd like to sidestep for a second to the issue of fees, just to make sure I can address those. The issue of.
That's the second issue. Isn't it?
Yeah, sure. And that's more of a statutory interpretation argument. Costs from the Office of Administrative Hearings were imposed. There's no real dispute about $34 and witness subpoena fees would fall within what could be allowed under 583056. The issue is how do you go through the rest of that statute to get to the $1,300 or so that they're seeking under the fees from the Office of Administrative Hearings. In our briefs, both sides have kind of gone through the statute that the OAH is not mentioned in 3656. If you follow the rabbit hole of references to other statutes, 3656 cites the 60-2003, which doesn't say anything about the Office of Administrative Hearing. But following again, another rabbit hole link, it's the 60-2001, which talks about docket fees. That doesn't really cover the Office of Administrative Hearings. So just based upon the statutory language and the interconnection of how those three statutes operate, you don't get to the fees under the Office of Administrative Hearings. But as the other issue then is 3056 does contain language which might say that list of the four items mentioned at the bottom of 3056 is not exclusive. And under that analysis, the district court had addressed 60-2009, which is a generic catch-all to allow those fees, and it ruled that the Office of Administrative Hearing costs would be the costs of other courts. We addressed that issue. The Office of Administrative Hearing is not a court, so that language is inapplicable. We're now at the stage where the appellee is basically arguing that just the reference in general under 7537-121, which is the authority for the Office of Administrative Hearings to conduct these hearings on behalf of the agencies, that should suffice. The problem with that argument, as we mentioned, is there's really no statutory authority for those fees to be charged. The Office of Administrative Hearings has been given the opportunity to have statute or regulations developed to charge fees and so forth, but the statutory authority isn't in there, which then ties into kind of the bigger argument, which is the fact that it says costs may be allowed. Is that just something which can be done for anything, or does there still have to be a statutory basis? And particularly in the case law under 60-2001-9, the courts have typically said or dug into, we want to see other authority, like in the case of attorney's fees under subsection 9 or other costs. So you just can't have this broad sweeping analysis that just because it says costs are allowed, that you don't have to have a statutory authority for occurrence costs. And so with that, I have 1 minute more. So if I need to, I can go back and touch on the factual disputes, but the biggest issue factually, and again, trying to give as much judicial deference to the findings of facts, there's no evidence that the appellant understood that the price is going to be $20,000 higher than the 120, which had been the current county appraisal. And then on the issue of the intention to rent, that of course is something which there's no obligation. There's never any discussion about that in terms of how long that is. That's not something which clouds title or prevents you from selling. And then the third issue.
But it does give a person selling you the house the impression that you don't think it's worth flipping. Like, if, you know, I'm going to keep it and rent it, you don't think that that demonstrates some intention or some belief that I can't make 40 grand on this house in 3 weeks?
I don't think it necessarily does. And the reason for that is there's always two ways to value property. One is cash flow, i.e. rental. The other one is to actually sell it and get your profit from the amount you bought it for and the amount you sold it for. I think the fact you're having a discussion that I may rent it or I'm thinking about renting it, that alone isn't sufficient to prevent you. And it's not reasonable to assume it can't prevent you from then selling it at some point. I mean, otherwise, how long does that term or that concept apply? Does that mean you can't sell in a year?
I mean, he didn't rent it at all, not even for a day.
Right.
So the timeline doesn't matter. It was a binary.
But it wasn't incorporated into the contract. And I understand that for fraudulent misrepresentation, that had to be incorporated in the contract, but there's no real discussion between the parties as to what that meant. And again, is it reasonable? Because sure, the way it turned out, it got sold pretty quickly. He did make an effort to get financing to do the work to improve the property. It's just at the time, the property market was so hot, he just sold it. And that's where we're at.
You've got 47 seconds.
Okay, for some reason, I had that clock wasn't working, so I had my stopwatch and it went to
Yeah.
11 minutes. I will just come back for my rebuttal.
All right. Thank you, counsel.
May it please the court, Deputy Solicitor General Dwight Carswell appearing on behalf of the Kansas Real Estate Commission.
Counsel, I thought it was a $40,000 profit here, but now counsel tells me that it's 20,000. Do you agree with that?
So profit, it depends because there were costs and fees and commissions. So the sales price was 102,706 from Miss Taylor. That's what he paid her for it. And then he sold it for I have that somewhere now. How did I put that? 139,900. So that difference would be, third, not quite.
I understand you're a lawyer, you're not a mathematician.
37,000 roughly. there.
37,000.
But the profit in the record is 27,762. So I think there are some costs that are deducted from that. So it kind of depends on.
Not a bad day's work, is it?
That's pretty good, yes. And that's the Kansas Real Estate Commission's finding is supported by substantial evidence
Are we bound by that?
by,
Their finding?
you defer to it under the substantial evidence standard. The question is whether a reasonable person could, based on the evidence in the record, agree with the agency's
And
finding.
looking through this record, there is substantial evidence, isn't there?
We completely agree, yes. And that's why you should affirm the district court's judgment. There's plenty of substantial evidence here. In particular, McGivern should have known, if he didn't actually know, that the house was worth substantially more than the $109,900 that he led Ms. Taylor to believe that the house was worth.
Why was appellant concentrating on the $120,000? He seems to have told Ms. Taylor that it was worth $120,000.
The evidence in the record is that he recommended that she list it for $109,900 and said in the kind of best case scenario, there might get into a bidding war and that could jack up the price to $120,000 in the best case scenario. So somewhere in there was kind of the range of, but that was again, the recommended listing price was the $109,900. So that's the baseline that they used for the sales price. He took that $109,900 and then deducted the commissions that he would have received, plus what the seller's agent would have received as well. So he took credit for that, plus the fees to get that $102,000 listing price. So just, yeah,
For
$102,000.
my benefit, I would prefer that you jump into the cost issue here.
Sure.
The costs are more than the fine, and the biggest element of that cost is for something that's not enumerated in any of the cost statutes. So explain why that's
Sure.
allowed.
Well, under KSA 58-3056, the first sentence there says the cost of any hearing before the commission may be assessed against the licensee or applicant if the order of the commission is adverse to the licensee or applicant. So assuming you affirm, which we think you should, the order is adverse. So the question is, are these OAH charges, Office of Administrative Hearing charges, the cost of the hearing? And they clearly are. I mean, that's what the Office of Administrative Hearing charges the real estate commission for holding the hearing. So it's the literal cost of the hearing. Now, McGivern seems to read the last sentence
I
of
don't
that.
even know if I should ask this question, but I will. Is this a cost that's assessed in any kind of hearing that you would conduct?
The Office of Administrative Hearings, yes, charges all agencies these charges, yes.
Okay.
It's not part of the commission.
It's not part of the commission.
It's a separate office.
It's a separate agency that's set up.
It's all other administrative, except those that have it in-house, right?
That's correct, yes. And the legislature generally requires agencies to use them unless there are certain exceptions. So they do, as a matter of course, charge agencies for their services to hold these hearings. And that's what happened here. Now, McGivern seems to read that last sentence in KSA 58-3056, which say cost shall include and gives a list of things as establishing kind of an exclusive list. But that's not what shall include means. That's normally include is a term of not exclusive meaning. It's a list of just examples. It includes but not limited to is how that's read. So so you don't need to just fit it into one of those categories there. Like, I mean, the district court did, but we don't think you need to. We think that very first sentence is sufficient to cover.
So your argument is if you're doing business with the real estate commission and you want to appeal it, you're going to be on the hook for whatever the costs of those appeals are to the OAH,
If you lose.
Office of Administrative Appeals.
If you lose. I mean, it's if the order is adverse to the licensee or applicant.
Correct.
If you prevail, then obviously you don't have to pay. But
Obviously.
yes, if you lose, then you have to pay the cost that the OAH charges. Those are the costs of the hearing, which is what the statute, plain language of the statute as we read it, requires.
And that's in that first sentence.
The first sentence says the cost of the hearing before the commission, which is clearly is the cost of the hearing, may be assessed if the order is adverse to the applicant or licensee. It seems pretty straightforward, just that sentence by itself. I mean, if that last sentence weren't there, I think it's pretty clear that this would be covered. Somehow you have to read that last sentence as limiting that first sentence, and we don't think you can do that because the word shall include is not a language of limitation. Didn't sound like you had a lot of questions about the underlying.
I I actually
Okay.
do.
Sure.
I think, I'm curious as to, what level of knowledge, fraud isn't defined here. I do know the Kansas general definition of fraud.
Sure.
Do we need to have facts to demonstrate that he knew the value of the house was $140,000?
So it's clear at the minimum that fraud encompasses knowledge or reckless disregard of the facts. And the district court here said at minimum there's reckless disregard. The state believes, or the real estate commission believes, that negligent misrepresentation is also included, but we don't think you need to go there. We think there's plenty of evidence to at least establish reckless disregard. And McGivern's briefing also, as I read it at least, acknowledged that reckless disregard is sufficient. The district court actually said it's very hard to believe that he didn't actually know there's a higher value, and we agree with that. A reasonable person could actually, so even if actual knowledge is required, we think there is substantial evidence of that as well. But at minimum, there's also evidence of reckless disregard, so.
Should we be concerned that they never signed the engagement agreement to actually hire him as a realtor? He was just a dude they were talking to.
I don't think that matters for several reasons. First of all, the district court did correctly state that you can have an implied agency agreement, and here we think that existed. I mean, he met with them, he walked through the house, he proposed the listing price, they agreed on a date to list the house. They clearly were on the same page that he was acting as their agent, but they didn't follow through. I mean, he sent her over the paperwork, and then that's when he called her up and said, would you be willing to sell me the house? So they were under this understanding that they were that he was acting as their agent, as it was an applied agency. But even apart from that, the statute that he was disciplined under, KSA 50-3062, says no licensee, whether acting as an agent, transaction broker, or a principal. So it's not limited strictly to agents. It's any licensee, even if they're acting as a principal rather than an agent. So the agency would really only come in terms of his argument about, McGivern's argument about an opinion as to value can't be fraud. And there, what this case law says, well, if you have a special relationship or special knowledge, then it can. And I don't think that's strictly limited to agency. I mean, here they clearly, even if he wasn't technically their agent, which we do think he was, there clearly was a special relationship sufficient to make his representations fraudulent or substantial misrepresentation, even if it's not fraud. But unless there are any further questions, I just urge you to affirm. Thank you.
Counsel, any rebuttal?
Yes, Your Honor, just a couple points.
All right.
On the issue of the agency, it is clear in the record that there was never any agency in terms of that agency agreement wasn't signed. And furthermore, under the two statutory acts governing real estate agents, you can't have implied. It's kind of a binary thing. You either are or you aren't, which is why when we focus on this implied agency and why it's not supported by the law, under A13, that's why to me it's pretty clear. It just says fraud or substantial misrepresentation, because yes, the preamble to that whole statutory list of multiple violations, most of those address people being done in their position as an agent or as a transactional broker. I think A13 is best interpreted almost sort of like the way lawyers are treated, where you just don't take your hat off just because you're not necessarily being a lawyer. And that's why the principle is in there. So yeah, under A13, as a principal, i.e. the buyer, he was obligated not to commit fraud. But I don't think it's at the level of being an implied agent, because that stopped because it was never executed. And it was clear that he was acting on his own behalf as a buyer. I do want to point out to the court too, I did not mean to sound flippant about the profit that was being involved. And when I was referencing the 20,000, where I was going wasn't the numbers quoted by the appellee. Where I was going was that to the extent that the parties understood that on a good day you get to 120. That the fact that it sold for 139, that was 19,000. I was not trying to be flippant about how you could interpret the various profits. But from our standpoint, it's like if everybody kind of knew and there's testimony on the record that the county appraisal value was 122, that it's 19,000 as opposed to the actual purchase price. Everybody understood how these calculations were going according.
Didn't all this occur at a time where there was actually a bidding war in the local market? If you put your house on the market for a certain amount, you'd usually get people bidding with each other for higher amounts.
That was starting to occur at that time, which is
So
why.
isn't that something that just makes this even more fraudulent?
No, because he references you might be able to bid and bid up. And he points out to him that work's going to have to be done on the house. And it also kind of boils down to this aspect too, which is who's bearing the risk? You have a tired home that may or may not sell as well as everything else is going. You don't want to put any money into it. Somebody else is going to take the risk of putting real money up front as is. You got that aspect. Is that 3 minutes or 5 minutes? Is that 3 or 5?
I had 3.
Oh, I asked for 5. So
All right, very good. You,
Okay, I'm
you
sorry.
got 2 minutes.
The last thing I want to talk about is the going back to the cost, Your Honor, which is the cases cited by the appellee deal more with include being more of a factual finding. For example, the district court case they cite to talks about common carrier shall include. That's more of a factual distinction in terms of this factual category of common carrier could be what we call these terms of art, but there might be something else. So it's not quite as expansive as saying that just because the word include is in there, that you don't just look at the 4 bottom allowed costs and then the statutes that reference those. But the other thing is, even if you do say that include by itself opens up a whole spectrum of things that you can look at, there's no authority to say that a cost just as costs are open-ended without any other statutory authority. And 70,
Why would this cost though be unreasonable? I mean, it's an actual cost they incurred to hold the hearing.
it's just like the court's interpretations of 2001 subsection 9 about attorney's fees. It says attorney's fees. And I think every attorney in this room would agree that everything we charge is reasonable. It's the cost of having a lawsuit. But the courts have routinely said that doesn't apply. There has to be more. You have to now use the American rule. There has to be a statute or there has to be a contract. So, and more importantly, because the sections that the Office of Administrative Hearing is authorized to conduct the hearings, there's nothing in that that says you're authorized on just that statute to charge the agency you're doing the work for. And I think that's a pretty crucial thing. It says you can develop a new statute of regulations to charge, but there's been no evidence here that whatever they're doing or there's no legal authority that whatever they're doing is something which in a separate act or a separate regulation allows you to charge the agency.
So let me see if I understand your argument.
Yes, Your Honor.
You're saying the act itself is not clear that if you participate in this and appeal, which you were entitled to do, you would be responsible for paying for the expenses to the Office of Administrative Appeals.
Correct, Your Honor.
You're not put on notice that you're going to be responsible for that.
If you look at the statutes, you wouldn't be put on notice.
All right, that's your argument.
Yes, sir.
Thank you.
All right, thank you.
All right. Interesting case. Thank you very much, counsel, for your arguments on this. We'll take it under advisement and issue a written opinion. All right, we'll move on then to our final case on the docket this morning, which is 128-133. In the matter of the estate of Rosemarie Fry, deceased. All right. For the appellant,
May it please the court, Judge. Jake Knight appears on behalf of the appellant, Pam Noonan.
And do you wish to reserve time?
Yes, 3 minutes, please.
3 minutes?
May it please the court, Bernard Irvin on behalf of the appellee. Right.
All right, thank you.
For the Ducks.
Yeah.
Judges, this is an appeal from a contested probate case regarding whether a tract of real estate is or is not an asset of the estate. It involves the interpretation of two deeds, an issue which this court has an unlimited or de novo standard of review. No deference needs to be given to the district court's interpretation of the deeds. That the tract at issue is not an asset of the estate. That interpretation was erroneous. Get into the deeds in just a minute, but I'll give you some background here. On December 15th, 1995, two deeds were executed to convey what will be referred to herein as the New Farm, consisting of approximately 160 acres, to William E. Fry, Rose M. Fry, William Eldon Fry, who's Bill, and Vicky J. Fry. One of the deeds was a co-conservator's deed, and it conveyed an undivided 3/4 interest in the tract. The other deed was a joint tenancy warranty deed, which conveyed the remaining undivided 1/4 interest in the new. Those deeds can be found in the record, volume 1 of the record on appeal at pages 86 and 88. They're also appended to the appellee's brief. William E. Fry and Rose Marie Fry were the parents of William Eldon, Bill Fry, Pamela Noonan, and Sherry Clark. William E. Fry died in 2004, and Rose Marie Fry died on June 18th, 2022. It's her estate that's ongoing, which is the subject of this action.
Counsel, I'm going to have to admit that this case brought back to me memories of when I started practicing law, and I read titles and examined titles for people. And I suggest now that you've got the facts out, let's get right to it.
Yes, Judge. So we got.
Why do we not have joint tenancy here? What's wrong?
The issue is not whether there's joint tenancy at all. It's whether there's joint tenancy between two couples. I think there's agreement between the parties that the deeds created a joint tenancy between each husband and wife couple. But the disagreement is on whether the deeds created joint tenancy between the two couples.
Yeah, explain that.
If you look at the co-conservator's deed first, it includes, it has 4 different paragraphs aside from the legal description. A preamble or introductory clause, a clause stating the conservator's authority to execute the deed, the granting clause, and the addendum clause. That introductory clause identifies the grantors and then states, and William E. Fry and Rose M. Fry, husband and wife, as joint tenants with right of survivorship and not as tenants in common, the so-called magic language, an undivided 1/2 interest, and William Eldon Fry and Vicky J. Fry, husband and wife, as joint tenants with right of survivorship and not as tenants in common, an undivided 1/2 interest as grantee. Then going down to the granting clause, which is paragraph 3 of that deed, grantors by these presents, grant, bargain, sell, and convey unto William E. Fry and Rose M. Fry, husband and wife, and William Eldon Fry and Vicky J. Fry, husband and wife, each couple having and holding their respective 1/2 undivided share in the whole as joint tenants and not as tenants in common. The important part there is that it's identifying that each couple holds their undivided 1/2 share in the whole 160 acres as joint tenants with right of survivorship.
Are you saying that creates a tenancy in common, those 3 words, each or 2 words, each couple?
That's clarifying that it's a joint tenancy for each couple. What's not included here is language that follows that says, and both couples holding their share in the whole as joint tenants with right of survivorship with each other. That language is not included in the deed. That would have created a joint tenancy between the two couples. But otherwise, it's vague or ambiguous as to whether there is or was intended to be a joint tenancy between the two couples.
So what are you asking us to do?
We're asking the court to reverse the decision of the district court judge and determine that the new farm is an asset of the estate of Rosemary Fry, an undivided 1/2 interest.
It's your contention that should we determine there's ambiguity in the language by nature of the omission of the joint tenancy language as to the couples, then the default would be not joint tenancy.
Yes, under KSA 58-501, the default rule, when a deed is not clear as to creating a joint tenancy, the default is tenancy in common. And so here, the deed, both deeds, and I'll get into the joint tenancy warranty deed, that's the title of it anyways. Both deeds are clear that there's a joint tenancy for each husband and wife couple, but they're ambiguous, unclear about whether there is a joint tenancy for the two couples together. The district court judge determined that there was no ambiguity and determined that the new farm passed to Bill Fry and Vicky Fry via joint tenancy upon the death of Rosemary Fry. As I noted,
Because William Fry had predeceased her, she died, and then it goes, according to the court, it went to Bill and Vicky Fry.
correct, Judge. As I noted, the language that's missing is that there's nothing following that each couple holding their respective 1/2 undivided share in the whole as joint tenants and not as tenants in common. Nothing following that and both couples holding their share in the whole as joint tenants with right of survivorship with each other. Now, appellee will point to the phrase "in the whole" as if that is the verbiage that created this so-called nesting effect, which is a unique argument that really has no case law to support it, but it's a unique argument nonetheless. They'll point to that language "in the whole" as somehow creating a joint tenancy within a joint tenancy. And that "in the whole" language, those three words, are really just referring to the entire 160 acres. It's not saying that each couple gets 80 acres. No, they get the benefits and burdens of the entire 160 acres comprising the new farm.
What was the district court's basis for determining that it was also joint tenancy as between the couples?
Well, that was just his interpretation of the deeds.
Based on the use of joint tenancy for the couples?
He read the joint tenancy with right of survivorship verbiage the same way that the appellee is arguing in this case, which is that it's not only creating a joint tenancy between each husband and wife, it's also creating a joint tenancy between the two couples together. And I can mention at the outset, this court has unlimited review. You don't have to give any deference to that interpretation. You can look at the deeds yourself and make your own analysis and interpretation. And I believe looking at the deeds separately as they should be, not together as the district court judge did and as appellee has argued here, you'll see that each has its own issues. The co-conservator's deed, like I mentioned, is very clear in the first paragraph and the third paragraph that it's joint tenancy between each husband and wife couple. That it's an undivided, each couple holds their undivided 1/2 share in the whole as joint tenants with and not as tenants in common. There is no clarifying language that it's joint tenancy between the two couples.
Would you agree with me if I would state that without specific language in the deeds, the presumption under Kansas law is that joint owners are tenants in common?
Yes, Judge. That's what KSA.
And it doesn't need to be divided. I mean, it's tenants in common of the entirety.
Correct.
But there's no rights of survivorship.
That's correct.
Now, that can be divided later between the two joint tenants. So there has to be some sort of manifestation of intent of ownership of rights of survivorship.
That's correct.
And you're saying that there is absolutely no indication of rights of survivorship between the two couples.
At most, Judge, the deeds are ambiguous as to whether the intention of the grantors was that there would be rights of survivorship beyond each husband and wife couple.
And
I'm sorry, I thought you were.
go ahead.
If we did, or looking at the joint tenancy warranty deed,
Yes, Judge.
that's got the each couple language there, but before that, before it says each couple, after it lists the two couples,
Right.
it says as joint tenants with right of survivorship and not as tenants in common. That's pretty clear, isn't it?
It is clear. If the deed had stopped there, then the district court judge's opinion and decision on the deeds would be much stronger. However, the language that follows that, which then clarifies that it's each couple holding their undivided 1/2 share in the whole as joint tenants with right of survivorship, that's what sort of muddies the waters. It's clarifying, I think, that the only joint tenancy that's intended is between each husband and wife couple.
You mean when it says comma, each couple?
Correct. Yeah, it says the deeds list the parties an undivided 1/2 interest for each. And then says as joint tenants with the right of survivorship and not as tenants in common, comma, each couple having and holding their respective 1/2 undivided share in the whole as joint tenants.
And it's also your argument that it's possible, because the language is different between these two deeds, for them to be interpreted differently.
That's correct. And that's actually what happened in this case is there's a third party administrator of the estate who's an attorney, Michael Kaufman, and he filed an inventory in the estate, which set off this whole domino of events because there was written defenses filed. But in his inventory, he listed the new farm as the estate having a 1/8 interest, which means he interpreted just this joint tenancy warranty deed as being as not creating a joint tenancy between the two couples. But he apparently interpreted the co-conservator's deed as
creating joint tenancy between.
correct, which sounds
Is
somewhat.
the opposite of what you would argue, I would assume.
I argue that both.
Oh, I know, but let's go worst case scenario. You would argue that the other one is more likely joint tenancy than that co-conservator.
I think the stronger argument, if I was on the flip side
It's
of
more
this-
ambiguous. The first one's more
The
ambiguous.
co-conservator deed is more ambiguous. The language in this joint tenancy warranty deed, specifically the language that Judge Malone pointed out here, could certainly be interpreted as creating a joint tenancy between the two couples.
Okay, counsel, you still have your rebuttal time.
Thank you, Judge.
May it please the court, as Mr. Knight said to you, your review of this case is unlimited. It's a question of law, their interpretation of two deeds in particular. We don't have to worry about medical records or anything else. We've got two documents to interpret. And I quoted in my brief a quote from the Thoroughbred versus Casey Royalty. We need not linger long upon what the district court was thinking or what it did not do in reaching its conclusion. And I don't want to linger long, but I do agree with Judge Goddard's interpretation of these deeds. And I think the language Judge Hurst asked about what Judge Goddard said. And what he said, if it was only going to be joint tenancy and ended between the couples, between them as husband and wife, there wouldn't be this additional language about joint tenants, undivided share in the whole as joint tenants and not as tenants in common.
Which document is he talking about there? Is he talking about both of them? Do they both say in the whole?
They both say in the whole.
Okay.
And, I also argue in my brief, and I think we as lawyers have a tendency to do things in a way that I think leaves fingerprints and fingerprints in the documents that we create. And these two deeds have language in them that make it look to me that the same lawyer's fingerprints are on both of these deeds, in that they both contain two different levels of joint tenancy explicitly, in that they create joint tenancy between each husband and wife in the very opening part of it. So for example, in the co-conservator's deed, it says William E. Fry and Rose M. Fry, husband and wife, as joint tenants with right of survivorship and non tenants in common. And it says William Eldon Fry and Vicky J. Fry, husband and wife, as joint tenants with rights of survivorship and non tenants in common. So we have that first use of the phrase joint tenants as rights of survivorship, non tenants in common, between the couples. So it's very clear between a couple, if one of them dies, the deceased spouse's interest goes to the surviving spouse.
That's clear.
That's clear, absolutely clear. But then it goes on and it uses different language in both deeds, both the co-conservator's deed as well as the joint tenancy deed, which says each couple having and holding their respective 1/2 interest. So we go back to that first phrase, each couple has a 1/2 interest, a 1/2 undivided share in the whole, 100%, as joint tenants and not as tenants in common. So Mr. Knight correctly pointed out that I used the phrase nesting. It was a phrase used at the district court as well. I'm not aware of any case law that talks about nesting, but I believe it's an appropriate phrase, an appropriate use of that word in this situation. And as I state in my brief, it creates a level of priorities. So the first priority is between the two spouses. If one of them dies, their share goes to their surviving spouse. And then the second level of priority is if both spouses die, then it goes to their share of the whole. The 100% goes to the surviving couple.
If the writer is taking the time to make it very clear that as between the couples, it's joint tenancy, I find it a little bit perplexing that I'm supposed to then just believe that this in the whole was supposed to do that same thing as between the couples, when actually that's a really important part.
I guess I will concede that it maybe took me a couple times in reading these deeds to get to my conclusion. And I don't think that's entirely unusual. I think we as lawyers, the devil's in the details, and we have to hone in on the key language in any document if we're looking at it for interpretation. And I think what you asked is precisely what this drafter was doing, in that they could have just simply said joint tenancy once, and the outcome would have been different. If we just simply said all four people as the grantees as joint tenants, and that's argued in the appellant's brief, that would have a different outcome, because then if one person died, then their interest in that property would go to the other three survivors.
Absolutely, but I feel like this goes against your argument, because by setting it up between the couples, doesn't it demonstrate an intent to keep it separate and have it in separate estates?
If we said each couple holding their 1/2 interest as joint tenants,
As opposed to this in the whole.
as opposed to in the whole, that's clearly the difference. We make a distinction in that first half, in that first grant of joint tenancy. We say undivided 1/2 interest between the couples. In the second one, we talk about in the whole. And that's what creates that nesting level of priorities between the couples, with the outcome being that the surviving person gets 100% of the property. They get the whole. It's explicit in these deeds.
What else could it mean?
I don't,
You use a term of art like that, in the whole. What else could it mean?
I don't think it could mean anything. And
We're
that's,
not to disregard words as surplusage when we're talking about deeds. We have to give effect to how they are written, correct?
we absolutely do. And that's why I believe, you know, after reading it, it is explicit. We have these two levels of joint ownership with rights of survivorship. The other thing I want to point out, and you know, some of the cases that we both have cited in our briefs have the language at the end of the deed where it talks about heirs, assigns, those types of words that we might see in ordinary deeds or other deeds. These deeds contain no such language. Again, going back to the intent of the grantors, which is what we have to look at here, that if we use the words heirs, then we wouldn't be talking about survivorship rights under joint tenancy. And there's no such language in these deeds. And the cases that have interpreted deeds have viewed that language as very important in the determination. There's no such language in these deeds. So I think I've covered my points. I guess I'd like to say to conclude that the district court made the right ruling here, properly determined that the phrase "in the whole" means that the final outcome is a joint tenancy between the two couples, and the decision of Judge Goddard's should be upheld. Thank you.
Thank you, counsel. What did we say? Did we say 3 minutes, counsel?
As long as you want to give me, Judge.
All right. Go ahead.
The fact that we've have Mr. Irvine admitting that it took him multiple readings of this deed to get to this interpretation that he's come to. I had to look over these deeds myself numerous times. We had Mr.
That's all we've
Kaufman as the administrator looking over these deeds, and he came to the conclusion that the estate has a 1/8 interest. My interpretation, and Mr. Johnson is the other attorney involved on behalf of one of the heirs. We came to the same conclusion that it's a 1/2 interest for the estate. And then we've got a title company that agreeing with that. Apparently there was another title company.
And we don't have any, well, it doesn't matter. Because we don't have any evidence of what the title company said. It doesn't matter because it's a question of law. The question is, what do we three rule? That's what you're interested in. But tell me why that language about the whole queers the deal for you.
My point with all that, Judge, was to note that all these different people have had different interpretations. It can't be that clear and unambiguous then. If there's all those different people looking at these same deeds and coming to these different conclusions. Now, in the whole, as I noted in my first remarks, that's talking about the entire fee simple estate for the entire 160 acres. That language, I'm sure you'd seen it if you'd done title work yourself, is not uncommon for a deed to say that this person has an interest in the whole estate. That's the whole estate. That's not saying the two couples together somehow morph into having a joint tenancy.
And I also remember when we omitted language about heirs, assigns, legatees, devisees, trustees, all of that. When that was omitted for a reason.
Correct.
What's your response to the case? There's not here. That's not here.
Well, that would have certainly muddied the waters because we had the joint tenant, it was intended to be a joint tenancy between each husband and wife couple. And having the heirs, successor, and assigns could have caused a dispute about whether each couple held their undivided 1/2 share in the whole as joint tenants. And that's what some of this case law is really on point about. There's not much case law on this specific issue, where you have two couples and whether it's a joint tenancy within a joint tenancy.
So you're saying that by saying one half, I'm looking at the joint tenancy warranty,
Okay.
one half undivided share in the whole. You're talking about a half undivided share of the 160, the whole is the 160,
Correct.
which makes sense. As joint tenants and not as tenants in common, then that is referring to the above, which explained that the couples were joint tenants.
Correct.
Okay, I see what you're saying.
Bottom line is if the intention was for the two couples to hold their undivided one half shares as joint tenants together, such that whenever William and Rose had both deceased, their half share then passed to Bill and Vicky Fry, the deed should have been much clearer about it. There could have been language, like I mentioned, that followed that, each couple having their undivided one half share in the whole right of survivorship, such as, and both couples holding their shares together as joint tenants with right of survivorship. That language was not included in there and should not be read in there. For that reason, I ask that the court reverse the decision of the district court and determine that the new farm is an asset of the estate of Rosemary Fry. Thank you, judges.
Thank you, counsel. This is a very interesting case. We'll take it under advisement and issue a written opinion. All right, court is at recess.